You may be seated. Okay, good morning. Let the record reflect that the defendant is present along with counsel for the defendant, assistant state attorneys. Both sides ready to proceed?
Yes, sir.
Okay, have you received the copy of the final instructions?
Yes.
Okay, before I will give them, you'll have an opportunity to make sure they are in proper form. So we have an opportunity just to double check them. Mr. Baez?
Yes, sir. I just wanted to clarify one issue with the state's rebuttal argument. We, of course, objecting to the court allowing them to now split up the arguments after the court had ruled previously that the only argument that could be split up would be their initial argument and not the rebuttal. And I certainly want to, I guess, make sure that this is just not a second closing argument as opposed to a rebuttal where, since Mr. Ashton during his initial closing argument actually covered quite a broad range of topics. And I wanted to raise and renew our objection to that. The remedy that they seek, they received when they objected. So that would be just our argument that we would like to lay out for Your Honor.
Okay. If they exceed what rebuttal is, the objection is simply objection, improper rebuttal, and won't take long for a ruling. It is rebuttal. That's what it's for. Of course, at the very end, there's a little latitude to briefly tie it all up, but it is rebuttal and solely rebuttal. Okay, let's return to jury. Good morning, ladies and gentlemen of the jury. Did you heed all of my previous admonitions? Okay. The state recognized the presence of the jury.
Yes, sir.
Does the defense?
Yes, sir, we do.
Rebuttal?
Good morning and happy 4th of July. Ms. Drain-Burdick and I are going to both speak to you at this rebuttal portion of our argument. We're going to discuss different topics. I want to begin by discussing the science in the case. Defense counsel issued a very appropriate and aggressive attack upon the science, but I want to take a more measured and complex approach. Science can't be understood by simplistic concepts or easy phrases. The best way to understand the science in this case is to look at it and first look at what the scientists agree on and then what they don't agree on. And basically, the way it works is it's up to you to decide with an expert, as with any other witness, what part of his testimony you believe or don't believe. And in a dispute between experts, it's up to you to decide which one you believe. And you may reject both. You may find one more credible than the other because of experience or because of just that what they said makes sense. So it's totally up to you to decide what you believe from what the experts have told you. But I think it might be helpful to start out kind of isolating these areas sort of by subject matter. The first one I'd like to start talking about is the experts you heard on the subjects of forensic anthropology and forensic pathology. Those are sort of related fields. Those are the medical examiners and the forensic pathologists, the people that looked at the remains themselves and what they told you. You essentially heard in this case from Dr. Jan Garavaglia, who is the chief medical examiner of the District 9 Medical Examiner's Office here in Orange and Osceola County. Dr. Utz, Dr. Utz was the gentleman who first took custody of the remains, who removed the duct tape and talked about that. You heard from Dr. Schultz, who is the forensic anthropologist, works out here at the University of Central Florida, and is a contract consultant for the medical examiner's office here. You heard from Dr. Michael Warren, who is the director of the Pound Human Identification Laboratory at the University of Florida. And you also heard from Dr. Werner Spitz, who was the defense's expert called on that subject. Now, what do all of them agree on? Well, all of them agree that, number one, there is nothing in the bones that tells us anything. They all agree. There is no traumatic injury to the bones, there's no breaks, there's no fractures, there's no injuries, there's no nothing. Just looking at the bones, they all agree that there's nothing to tell us how Caylee Anthony died. Everyone agrees to that. The other thing they all agree about that is significant in this case is that because of the way the human body decomposes, there are two parts of the head that should not be together. That is the mandible and the skull. Dr. Spitz even said, remember he talked about when you picked up the skull, the mandible would stay on the ground. They're not connected. Once they decompose, there's nothing to keep them together. And what they all also agree about in this case is that when Caylee Anthony's body was found, the skull and the mandible were still in what they refer to as anatomical position. In other words, it was in the same position it would have been had the flesh and tendon been holding it. Where they disagree is on why that was the case. Dr. Utz, Dr. Gervalia, Dr. Schultz, and Dr. Warren all told you that the only thing that could have kept that mandible in anatomical position is the tape. Remember, Dr. Warren told you, and he is, I would submit to you based on what you've heard, the most experienced of the four in forensic anthropology, in skulls. He's told you that the only other time he has ever seen a skeletonized, fully skeletonized body with the mandible and the skull in anatomical position is in Sarajevo, in a skull of a person that was duct taped. So they have told you that in their opinion, which again, you may accept or you may reject, that that tape had to have been on that skull before she decomposed. Dr. Spitz presented you with an alternative. And I discussed that alternative with him at length. His alternative was that someone had come along at some later point for some unknown reason and reached down and picked up the skull off the ground, then picked up the mandible, took them someplace, put them back together, and duct taped them to hold them in place, and then returned them to the scene. You heard the cross-examination of Dr. Spitz about that scenario. And it is up to you to judge whether that scenario is reasonable or makes any sense at all. When I pointed out to Dr. Spitz that his scenario of the skull being returned was inconsistent with the, first of all, the deterioration of the duct tape, and second of all, most importantly, remember I asked him about, well, the person would not just have had to put the skull back, they would have had to have draped pieces of hair over the skull. And remember what his response to that was? His response to that was to accuse the medical examiner personnel of doing it. And then when I showed him the photograph of the skull at the scene, undisturbed, with the hair in exactly the same place, he accused the sheriff's personnel of doing that. It is up to you to decide which of those two expert opinions you find more credible. And I submit to you, based on the evidence that you heard, that Dr. Spitz's version of events is incredible and non-credible. And I'll get to later in my remarks that it actually is also inconsistent with the very theory that the defense has been presenting to you in the other parts of their argument. We'll get to that in a little bit later. The other area that they disagreed on was the appropriateness and necessity of sawing open Caylee's skull. Dr. Spitz told you that that it was a violation of protocol for Dr. Garavaglia not to have sawed open Caylee's skull, and that it was, in his words, sloppy. On cross-examination, however, when challenged, even with his own book, to demonstrate where that protocol was set down, he was unable to do so. When asked if there was any protocol he was aware of dealing with skeletal remains that required such an act, he admitted there wasn't. In response to that, we called Dr. Michael Warren back again, the director of the Human Identification Laboratory, to tell you that, in fact, it is not protocol. In fact, it is contraindicated to open a skull unnecessarily. Because there may be times when there may be some particular artifact that cannot be otherwise appreciated, but generally, no, skulls are not opened. It is not sloppy to fail to do so. In fact, it is dangerous to open the skull, particularly in a child, because when you do that, the skull breaks, as Dr. Spitz did. Remember, I asked Dr. Spitz, you broke the skull, didn't you? And he was like, I don't remember that. And I showed him the photograph where the skull is fractured, and he didn't seem to remember. And I would submit to you that based upon what you have heard in this case, that Dr. Spitz's claim that the autopsy was done improperly is not credible. The other issue that they disagree on is this issue of the supposed, and this was sort of my shorthand term, but brain dust or brain residue. He referred to that as like dust in the skull. He says that there was this residue in the skull that he could tell by looking at it was remnants of the decomposition of Caylee's brain. And because of the position that he could tell that the skull was on its side. He acknowledged that he took a sample of it, that he doesn't know if it's ever been tested or not. So we brought in Dr. Bruce Goldberger from the University of Florida, who washed the inside of the skull, tested it, and told you that there is no decomposition product inside that skull. So he did the test that Dr. Spitz said he didn't do, said he couldn't do because he didn't have a laboratory. And we now know that it's not what Dr. Spitz thought it was. So Dr. Spitz's whole theory of that proving that the skull was on its side has now been disproven. You'll also recall in cross-examination, I pointed out to Dr. Spitz that the arrangement of the hair mass was not consistent with his theory of how the skull decomposed. That, in fact, remember we talked about how the hair, if the skull is on its side, the hair mass is going to fall to the side, it's not going to fall evenly, blah, blah, blah. And you can look at those photographs, you'll have them all back in the jury room, and you can look at them and you'll see. I also asked Dr. Spitz an interesting question that counsel somewhat criticized me for asking. He acknowledged that in determining the manner of death, it is absolutely essential for a forensic pathologist to know about the events leading up to the death or disappearance of the victim. It's common sense. He said, yes, you have to know that. You have to know as much as you can about that. So I asked Dr. Spitz, well, what did you know? What information were you given? What research did you do? He said, well, I went to the house. Well, what do you remember from the house? just that there was a pool. That's all he remembered. Well, what did you know about the events, leading up to her disappearance, et cetera? Well, there was something about a nanny. That's all he knew. I would submit to you that his fund of information about this case is not sufficient to make his opinion credible in this case. That, in fact, the evidence in this case shows that the medical legal investigation of this case was thorough and complete, and that the testimony of Dr. Garavaglia and Dr. Utz and Dr. Schultz and Dr. Warren is credible and is worthy of your belief. Now, let's talk next about the entomological evidence. It wasn't a big feature of the case. It wasn't huge, but counsel referred to it, so let's talk about it. You heard from two entomologists. One was Dr. Neil Haskell. Been practicing in this field, has been a leader in this field for, I think he said, 30 years, practicing in forensic entomology. He told you two opinions, essentially. One about the car and one about the scene. You heard from Dr. Timothy Huntington, who has been practicing in his field since he received his PhD in 2008. A very bright young man, and I don't mean to denigrate his education or his sincerity. But the fact of the matter is you have to decide who you find more believable. Someone who has been practicing in the field for 25 or 30 years, or someone who's been practicing in the field for 3. But again, there are things they agree on. They agree on this very important fact, that the evidence at the scene where Caylee's body was found indicates that the body initially decomposed in some other location from which the early colonizing flies were restricted. That's what Dr. Haskell told you. Dr. Huntington said he agreed that wherever Caylee's body was for the first few days of decomposition, those early flies could not get to her. And then she was taken and dumped there in that in the woods, in that swampy area that you heard described by so many people. They both agree that that occurred sometime in June or July of 2008, based on the entomological evidence. In that, they agree. So what Dr. Haskell said about the scene, Dr. Huntington agrees with. Where they diverge is in the single issue of whether the trunk would have excluded the early colonizing flies. That's the only place that they disagree. Dr. Haskell, with his 25 years of experience in the field, has told you that in his opinion, the trunk is a source that could have excluded the early colonizing flies. Dr. Huntington, who candidly admits that he has never in his career dealt with a dead body in a trunk in a real-world situation. But based upon some experiments, applying conditions completely different than in this case. Remember, that's the pigs in the blanket comment that we made. That based upon that experiment, and that experiment alone, he renders the opinion that the trunk would not have excluded the early colonizers. Again, it is up to you to decide which expert is more credible, or which you believe, or to believe neither. It is completely up to you. But the important thing is on what they agree. That that body decomposed someplace else, that it was somehow, either by being wrapped or being stored, was in a situation where the early flies could not get to it. And that from June or July through December, it sat there in the woods. On that, they agree. All right, let's go to the area next of the chloroform. Mr. Baez had a nice big poster about that. had all the experts or people that talked about chloroform. What is important to understand in evaluating the various people who testified about chloroform is to understand, first, what they were testing, and second, what their perspective was. Now, remember, Mr. Baez made a good deal of comment on the adjectives used by Dr. Voss and Dr. Weiss versus the adjectives used by Dr. Rickenbach. But one thing you have to understand in assessing those adjectives is their perspective. Dr. Voss and Dr. Weiss are used to looking at environmental air samples. Remember, Dr. Weiss told you that he's looked at environmental air samples from all kinds of different, fuel, car exhausts, environmental conditions, industrial, all different areas. And he's told you that based upon that experience, that he felt that the amount of chloroform he was seeing in the sample from the trunk was high, was surprising, because of what his experience is. Dr. Voss's experience is similar. What he's looking at is samples from dead bodies, and he's seen many of them. He told you that based upon what he has seen in decomposing bodies, and he has occasionally seen chloroform in those cases in very small amounts, but compared to that, what he saw was shockingly high. But taking away the adjectives, the important thing is more to say, what did they actually find? Dr. Weiss and Dr. Voss told you that the chloroform they found in the trunk air sample in the can was somewhere in the low parts per million range. And Dr. Weiss gave you an excellent explanation of the idea of quantification. He said quantification would not have meant anything in this case, because even if you quantify the amount of chloroform in the being given off by the carpet, it doesn't mean anything in terms of the amount of chloroform that was there a month before, because chloroform is volatile. It evaporates. So it wouldn't mean anything. But he does say, and Dr. Voss says, that based upon the qualitative analysis and the comparison between the amount of chloroform and the limits of his machine and the controls, that it was somewhere in the low parts per million range. Dr. Rickenbach from the FBI tested a similar sample out of a can, but also tested the actual spare tire cover in this box. Now remember, he received it in this box, not sealed, not in a can, not in plastic, in air-permeable cardboard. And what was interesting that Dr. Rickenbach told you is that he actually found chloroform, detectable chloroform, even in that. Remember, he told you he was surprised. He couldn't believe he found it, because chloroform is a volatile, and this is not sealed. So he said the fact that he found anything on that was pretty amazing. But remember, what he told you was that he found a much greater amount of chloroform in the sealed can. Remember, I think I had him put some numbers on a board, and it was in terms of percentages of the control. The control was 100 parts per million. In this item, I think he's put it at 0.08% of the control. In the can, it was 5% of the control. And again, he has said, and we will tell you, that is not a quantification. It is not a precise quantification. It's not intended to be a precise quantification. But what's interesting about it is that the rough estimate puts it in the low parts per million. The same thing that Dr. Voss found. Now, to Dr. Rickenbach, who is used to looking at chloroform in its liquid form, that wasn't a lot. But he told you, this is the first time I've ever found chloroform in any kind of solid object. Every time I've looked for chloroform, it's been in the liquid form in adulterated liquids of some sort, in case it was being investigated. But even he said that he found detectable amounts of chloroform coming from the carpet in Caylee Anthony's car. Nothing that he'd ever seen before. And that's the significant thing about these witnesses, is they all told you the same thing. This is the first time we've seen this. Actual detectable amounts of chloroform coming from a carpet. And remember what they told you. Dr. Rickenbach agreed. The amount of chloroform in these items is far less than the amount of chloroform that would have been in that trunk a month before, because chloroform is volatile. It evaporates. It fills a space until fresh air comes in. Remember, this car was aired out by the Anthony family for hours on the 15th going into the 16th. So the chloroform that would have been there before it was opened up, when it was at the tow yard, was far greater than anything these people found. And ladies and gentlemen, I would submit to you that there has been absolutely no evidence to explain where it came from or why.
Overruled.
Dr. Sigmund, who was the gentleman from UCF that did his initial testing of the sample, he told you that he tested the trunk 4 days after that item was removed. 4 days, it had been gone for 4 days. And yet even 4 days later, he was able to detect, even with his equipment, which he said is not as good as what Dr. Voss used. It's not as, it doesn't capture as much. Even he was able to find detectable amounts of chloroform in the trunk of that car, which shouldn't have been there. There shouldn't have been any chloroform in the trunk of that car, but it was there. Dr. Sigmund also told you something that was very interesting. He told you that while chloroform can be created by incidental contact between chlorine bleach and organic materials, that doesn't happen in a vacuum. That when that does happen, other compounds are created. And those compounds have not been found in this case. All that's been found is chloroform. No chlorine. Remember, I asked Dr. Furton, there's no bleach stains on that spare tire cover, are there? No, there's not. There's no, the issue was brought out that some cleaning products have small amounts of chloroform in them. And I asked Dr. Furton, were any of the other constituent components of cleaning products found? No, they weren't. All that was found in the examination of that carpet and that spare tire cover were the components of decomposition and chloroform. In that, all the experts agree, including those called by the defense. Let's talk about now another subject as far as the air examination, which is the odor of decomposition, the expert testimony. The defense's primary attack upon Dr. Voss is that he has developed a device which is designed for use by law enforcement and the military. And that if by some miracle that device were to be purchased by someone in the private sector, why they would want to, can only guess, that Dr. Voss would split with the other inventors 15% of whatever minimal royalty that Oak Ridge National Laboratory might get. That's the impeachment. That's the criticism. You saw Dr. Voss testify in this case, and you have to judge his credibility. I submit to you that Dr. Voss is an unapologetic geek. He loves what he does. I mean, when have you ever seen a scientist on the stand in a criminal case say, and this is the cool part? Dr. Voss is an unapologetic science geek. He loves the challenge of solving scientific questions. Whether it be how do you detect a body by the odor of decomposition, or whether it's maybe divining actually does work. You know, counsel sneered at him because he has the scientific curiosity to wonder if something as bizarre as that might actually have a scientific basis. Maybe he's right, or maybe he's wrong. But to say that you should disbelieve him because he has that scientific curiosity, I would submit, is inappropriate. You know, judge him by what he said. Judge him by who he is and what his experience is, and judge him fairly. But getting back to that point, when you actually boil down what Dr. Voss said and what Dr. Furton said, they really don't disagree that much. They both agree that the science of human decomposition odor has not developed to the level that there is a signature set of compounds that show human decomp. They both agree with that. They both agree that the chemical signature from this car is consistent with a decompositional event. Dr. Furton said, yes, I believe that those chemicals are from a decompositional event. So does Dr. Voss. Dr. Furton agrees that it's possibly human. And that's what Dr. Voss says. They don't really disagree that much on much of anything other than the final conclusion. Because Dr. Voss told you that when you combine the science with his experience and what he smelled in that can, the odor that he has smelled for 30 years, I asked him, do you have an opinion based upon all of that as to whether that odor was from human decomposition? And his answer was, I can find no plausible other explanation. And I would submit to you that Dr. Furton's other explanation is not plausible. You know, counsel in direct wanted to just have Dr. Voss talk about the garbage from a photograph without talking about what was actually there. But I wanted Dr. Furton to actually look at the garbage. Because I wanted you to see what was actually there. In his closing remarks, counsel made a claim that I would submit to you is completely unsupported by the evidence. He told you that these officers removed something from the garbage. That is absolutely unsupportable in the evidence in this case. There's no evidence of that. In fact, the evidence is completely to the contrary. The officers testified they removed nothing from that garbage bag, that there was no food there then, there is no food there now, and all the imagination in the world is not going to create it. The only thing in that bag of an organic nature, similar to food, was the small bit of remnant of cheese that I passed around for you to look at. And Dr. Furton admitted that that cheese in that bag could never create an odor that would still be detectable by Tim Huntington, the defense own expert, 2 years later. The myth of the garbage has been disproven. That smell was not from garbage. It was from Caylee. The defense presented, let's talk about DNA for a minute. The defense presented DNA non-evidence. The defense called a DNA expert from the FBI to testify that she tested for DNA on various items, and there was none. And she told you that she didn't expect to find any. That DNA decomposes just like every other part of the body does. And that she had no expectation of finding DNA on the tape that had been out there on the body for 6 months. The defense called, Dr. Eichenblum, who really just testified, and remember, he is the witness who provided us with a report 2 days before he testified. The judge instructed you on that, and that you could determine that in judging his credibility. But all Dr. Eichenblum really said was, well, I think I might have been able to find something. That was the essence of his testimony. I think I might have been able to find something, but I might not. That's it. That's essentially what he said. But even he admitted that the two things that were absolutely the most destructive to DNA are moisture and heat. And that it was highly unlikely that any DNA could be found on the duct tape. I mean, think about it. If there's no DNA on the face to which the duct tape was attached, how can there be DNA on the duct tape? And they admitted that. That was non-evidence. It didn't mean anything. The defense called 10 other witnesses to basically talk about non-evidence that the witnesses themselves admitted was meaningless. It doesn't mean anything. The fact that there's not dirt on a shoe doesn't mean the shoe wasn't in the place. We could go on and on with that. It just doesn't mean anything. The last area of forensic evidence was the hair examination. In the hair examination, you heard from Karen Lowe and Stephen Shaw. Stephen Shaw was recalled by the defense, and we went through that PowerPoint with you about his research. Those witnesses are not going to come up here and tell you more than the science will absolutely support. What they told you was that there is this artifact that has only been seen in hairs taken from decomposing bodies, that despite all of their efforts to recreate it from living human beings, they have been unable to do so. Since they don't know exactly what causes it, they're not going to tell you that it couldn't happen any other way, but just no other way they can think of. And that testimony, ladies and gentlemen, has not been refuted in this case. To say that there is no evidence to connect Casey Anthony to Caylee's death ignores all of this evidence. I want to go to the next issue I want to discuss with you is the issue of reasonable doubt. It is up to you to decide whether a doubt which has been proposed by counsel are reasonable doubts or whether they are speculative, imaginary, fanciful, and absurd doubts. So I'm going to go through some of the reasonable doubts proposed by counsel and subject them to a little bit of examination. The first area I want to discuss with you is the duct tape. Counsel went to great lengths to connect, as we already had, the duct tape in this case to the Anthony home. On that, we agree. That duct tape on Caylee Anthony's face came from the Anthony home. But so the argument then goes, well, George Anthony, having somehow discovered this drowning, which we'll talk to a few minutes ago, there's no evidence actually happened, for some reason decides to dispose of the evidence of this completely innocent accident. And for some reason that no one can even propose, decides to put duct tape on Caylee's face. Now, getting past the fact that there's just no conceivable reason why anybody would put duct tape on the face of a dead child. I said it before. People don't make accidents look like murder. That's absurd. And nothing has been presented to you to make that any less absurd.
Sustained.
Moves to strike, Your Honor.
Motion to strike granted.
You have heard nothing in the evidence in this case to make that proposition any less absurd. Now,
Overruled.
but let us propose that we ignore all of that absurdity and say that George Anthony has.
Paragraph 6 of Your Honor's order.
Overruled at this point.
And let's suppose that George Anthony has, in fact, placed Caylee's remains in the wooded area on June 16th of 2008 and placed duct tape over her mouth. The defense then asserts that on the 24th, for some reason, he deliberately notifies law enforcement about this gas can with the duct tape on it, implying that in some way he is attempting to implicate his daughter in something for reasons which are completely inexplicable and not mentioned anywhere in the evidence. But he creates this issue about this duct tape by reporting that it's stolen. He gets the can back. No photographs are taken of it by law enforcement back in June when it happens. It's just reported. There's no way of knowing from that report whether duct tape was on it or not. It's just not mentioned. But somehow the defense wants you to believe that that was part of the plan. That was part of his insidious plan to somehow implicate his daughter in something for some reason. They then tell you that when Caylee does turn up missing and the police are there searching, that George doesn't tell them about the gas can incident. If George is concocting a nefarious plan to implicate his daughter in this accident, then why doesn't he tell the police that first day? And counsel made great point of the fact that he didn't. But if counsel is correct, then he would have. He would have done it. Of course, why he would give the police a piece of evidence implicating himself as much as anybody else, again, sort of begs the issue. But anyway, so we go on. So the police take the item, which at the time they have no idea has anything to do with anything, photograph it, and then give it back to him. So at this point, George Anthony takes the can back and sticks it in a garage for 4 months and doesn't do anything with it. Doesn't try to connect it to the police, he just lets it sit there. And then in December, when the body is found, the police find the can with the duct tape in the garage. George doesn't point it out to them, they find it, because remember, George isn't even there. They find it and they take it into evidence. So what does this nefarious criminal then do? He takes the very same roll of duct tape, which connects him to this death, and he uses it to display posters. Does any of this make sense? None of this makes sense. To assert that George Anthony's use of the tape on the posters for his missing granddaughter is patently absurd. It doesn't make any sense.
Objection, Judge. Paragraph 6. Move to strike.
Overruled.
The reason that it doesn't make sense is because it's not, I submit based on the evidence, true. George Anthony had absolutely no idea that that roll of Henkel duct tape had anything to do with the death of his daughter, of his granddaughter. He had no idea, because he wasn't involved, just as he told you. You know, counsel showed you the big poster with the pictures of Caylee walking into the pool and said that this hypothesis has not been rebutted. Well, I respectfully disagree. Because, ladies and gentlemen, the two people that counsel asserts were present when that happened were George Anthony and Caylee Anthony. And George Anthony testified on that witness stand the first day of this trial. It didn't happen. And as Ms. Burdick will point out to you when she speaks to you in a few moments, Ms. Anthony also was given the opportunity to adopt that and rejected it twice. That has been refuted by the evidence in this case. Counsel also asserted to you that this crime scene was, quote unquote, staged. And here's the interesting part. He tells you, on the one hand, that George Anthony is connected to the tape. Remember, he said in opening, follow the tape. But then on the other hand, he tells you that Roy Kronk is connected to the tape. Remember, Dr. Spitz told you that somebody came along later and took the skull and taped it. And in opening statement, the defense counsel told you that person was Roy Kronk. So they both got the tape, this rare kind of duct tape. Roy Kronk, who has no connection to the Anthony family other than reading their meter once, who's never been in their house, who's never been in their garage, who have no way of knowing what kind of duct tape they have. So which is it? Who put the duct tape there? Counsel has argued to you that the crime scene was staged. Could I have State's Exhibit 82 published to the jury, please? You'll recall this is the photograph of the scene out there on Suburban Drive as it was found on December the 11th of 2008, before anything was disturbed. This is in its pristine form. And I will submit to you that looking at this scene, it is clear that the only thing that has staged this scene is Mother Nature herself. This scene is covered in leaf litter. There is a 2 to 3 inch pile of leaf litter surrounding the skull, as testified to. There are vines literally growing over everything in this scene. There are vines, you'll see in photographs, growing through everything in this scene. This scene is staged by Mother Nature and no one else. This skull has not been moved for 6 months. Pardon me, maybe a little bit less because the animals might have moved it before it decomposed. Mr. Defense counsel told you in opening statement that Roy Kronk took the remains home and kept them. We presented the testimony of Dr. John Schultz, the forensic anthropologist who was in charge of the collection of the remains. And we went through great length with him to show you where the remains were found and in what groupings. The reason that was important was because the grouping of the various bones demonstrates how the body was disarticulated during decomposition. Remember, he talked about how there were certain areas where the ribs were found because the trunk would have been removed as a connected group of organs as it decomposed, that the vertebrae were found separately because that would decompose separately. The bones showed evidence of
Overruled at this point.
that the bones showed evidence of animal activity, that they'd been chewed on. We didn't tell you that just to offend you or to make you mad. We told you that because it is essential for you to understand that these bones were not scattered by Roy Kronk. They were scattered by animals and by acts of nature. Could I have 207, please, in evidence? Again, you can see from this photograph a little bit closer up of where the skull is. This skull has not been moved for months. It is surrounded by the hair, which has fallen directly from the top of the head. You can see it all around, pretty much evenly distributed around the skull. This is where the skull has sat since the hair and the scalp decomposed and fell off. And it hasn't moved since, at least not much. Could I have the stage 209? The duct tape. The duct tape is partially covered by leaf litter along the sides. Remember, when you see the next photograph, you'll see this, the duct tape actually goes around the jaw and the skull. This has been here so long that the leaf litter has actually covered parts of the duct tape.
Rebuttal, Your Honor.
Overruled.
Could I have 218, please? In this photograph, you can clearly see that the duct tape wraps around the mandible. It didn't just get washed there by water. It's there because that's where Caylee Anthony put it. It's there. The jaw is in place because the tape is there. Could I have 220? You can see in this photograph where the tape has now been lifted away from the skull, from the mandible, excuse me, that there are strings from the tape that actually go under the mandible. It's not a coincidence. It's not an accident. That's not water. That's because the tape was placed over her mouth and her nose before she decomposed. You can take it off now. The scene was not staged. It appears as it does because of the forces of nature, the forces of water, forces of animal, and the forces of decomposition. And any suggestion to the contrary, I would submit to you, is conclusively refuted by the evidence in these photographs. All these photographs you will have in the jury room with you. They're in a notebook. They're separated by sort of subject matter, so you can go right to them, look at them, take as much time as you like to look at them. And when you've done that, you're going to see that this crime scene was not staged. It was not moved. That duct tape has been on Caylee's face since the day that she died. Just as the state's experts told you. The state did not call Roy Kronk in this case because Roy Kronk testimony about what he did on December the 11th, 2008 is embellished. Roy likes to spin a good yarn. But what Roy said he did on December the 11th isn't possible. We didn't put Roy Kronk on to tell you a story that the evidence indicates just isn't true. And I would also submit to you that Roy's claim that he just happened upon that scene for the second time is equally uncredible. That doesn't mean that he staged the scene, that he stole it, all that stuff. What it means is that Roy likes to spin a good yarn. I submit to you, based on the evidence, what occurred in this case is that Roy found the skull, as we know he did, back in August. He tried to report it 3 times, and he got blown off and said, "To heck with it. I'm over this." Maybe it really wasn't. But then he starts communicating with his son. He starts telling his son, "Hey, I know where the skull is." And his son is impressed. He's trying to get this relationship back with his son, and he thinks, wow, wouldn't it be great to impress my son? So he goes back to the scene, and it's still there. And Roy becomes a hero. And Roy tells a very, very dramatic story about lifting up a bag and the skull rolling out, and it's dramatic and it's wonderful and it's fun, but it isn't true. Roy found the skull all right, absolutely, but not the way he said. It's just impossible. But that doesn't make Roy Kronk a morally bankrupt individual who would take a little girl's skull home and play with it. The judge is going to give you some legal instructions, and I want to talk about a few of them, the most important ones. The judge is going to instruct you on the main charge here, which is murder in the first degree. There are 2 ways to commit murder in the first degree. One is called premeditated murder, and the other is called felony murder. Now, we get up here and we argue to you what scenario we believe the evidence supports. And in this case, we've told you that we believe the evidence in this case supports the scenario that Caylee Anthony chloroformed Caylee so that she would not suffer, placed duct tape over her nose and mouth to end her life, and then disposed of her body. But you can come up with whatever scenario you want. I mean, it's up to you to put these facts together and decide in your own mind what you think happened. And that's important in this circumstance. There are 2 ways to commit murder in the first degree. The important thing is for you to know the following. During your deliberations, in order to find the defendant guilty of murder in the first degree, the state must convince you beyond a reasonable doubt of the defendant's guilt of either premeditated murder or felony murder.
Your Honor, I want to object to a misstatement of the law.
I'm reading directly from the jury instruction.
Overruled.
Either premeditated murder or felony murder. While you must all agree that the state has proven first-degree murder beyond a reasonable doubt, you need not be unanimous in your opinion as to whether that finding is based on premeditated murder or felony murder. In other words, what that means is that as you each individually assess these facts, you don't have to necessarily agree on whether it's premeditation or felony murder. You can think it's both. Some can think it's one, some can think it's another. The important thing is that you all agree that it is first-degree murder in some form. Premeditated first-degree murder is a fairly simple concept. It just indicates the 3 elements are that Caylee is dead, the death was caused by the criminal act of Caylee Marie Anthony, and that there was a premeditated killing of Caylee Marie Anthony. Killing is defined as killing after consciously deciding to do so, and there is a more full description the judge will give you. Our position is that the facts in this case show beyond a reasonable doubt that this was a premeditated murder of a young child. But we know that you can reconstruct these events in any way you want. So you also need to know what felony murder is. Felony murder has 3 elements. The first is the same, that is that Caylee is dead. The second is the death occurred as a consequence of and while Caylee Marie Anthony was engaged in the commission of aggravated child abuse, or she died while Casey was attempting to commit aggravated child abuse, and that Casey is the person who killed Caylee. Now, aggravated child abuse is defined by two elements. The first is that the defendant knowingly or willfully committed an act of child abuse upon Caylee, and in so doing caused great bodily harm, permanent disfigurement, permanent disability, or permanent disfigurement, and that Caylee was under 18, which there's no question that she was. Child abuse is defined as the intentional infliction of physical or mental injury upon a child, or an intentional act that could reasonably be expected to result in physical or mental injury to a child, or active encouragement of another person to do that. The reason that we talk about this is you can postulate a number of different...
Under Brooks?
Overruled.
A number of different hypotheses in this case. Some might say, well, maybe Casey put the duct tape on Caylee to keep her quiet. Maybe she was being loud. You know, maybe she put it on to keep her quiet and put it on too tight, and Caylee died by accident. I would submit not really consistent with what we have here, but you know, someone could think that. The reason I bring this out is because if that is what you think happened, that is felony murder, as the court will define it for you. That's felony murder, because it is the intentional act that could reasonably be expected to result in physical or mental injury to the child. So if that's something that you're thinking about, just want you to know that's also first-degree murder.
Of the law, Your Honor.
Overruled.
Or if you choose to believe that she used the chloroform to sedate Caylee so that she could spend time with her boyfriend, as bizarre as that seems, but let's say that she used the chloroform in the trunk of the car to sedate Caylee so she could go have a good time with Tony on the 16th, and that Caylee accidentally died. It's still first-degree murder, because that act is aggravated child abuse, and if she dies as a consequence and the result, it's first-degree murder. So regardless of how you put these facts together, and again, I submit to you that the one that makes the most sense is that this is premeditated, because it is. But any way you slice it, any way you put it together, Caylee Anthony is guilty of murder in the first degree in this case. I want to talk a little bit about George. Here it is. You have seen hours of videotapes of conversations between George Anthony, sometimes with Cindy and Casey, and sometimes just with Casey. Those give you a window into this relationship between them. An unguarded, unvarnished window into the relationship between these three people. Is there anything in any of those conversations that shows George Anthony as anything other than a loving father and a loving grandfather who is out of his mind with worry over Caylee and perplexed as to why his daughter won't tell them something? Throughout all of these conversations, he is supportive, he is helpful to Casey, he's loving to her. She even says to him on more than one occasion, when he expresses some guilt about not having been a better father, she says to him over and over again, "You were the best dad. You were a great dad. You were a great grandfather. There's nothing in any of those tapes that would suggest in any way that he's setting her up in some bizarre fashion. Most of her more frictional relationship is with her mother. Most of the arguments, to the extent that they occur, are with her mother, not with her father. You know, remember the thumb? George is the thumb. We're the five fingers and George is the thumb. It's almost a little silly in a way, but George is not this Machiavellian, self-interested monster that counsel has suggested. The last time George Anthony testified, Mr. Baez brought up the suicide. You'll recall that he asked Mr. Anthony, you know, didn't you attempt to commit suicide? Mr. Anthony said that he did. Mr. Baez asked him, well, didn't you express some guilt in the suicide letter? That's, of course, before you actually would have had a chance to see it. Now, of course, Mr. Baez seems to be telling you that it wasn't really a suicide attempt. It was just a couple of beers and some blood pressure medication. That's not what George Anthony said. George Anthony said he took blood pressure medication and medication he was given for anxiety by a psychiatrist. He took everything he could find. Because on January 22nd of 2009, he wanted to die. He wanted to be with Caylee. That's all he wanted. He was tired of all of it. He was tired of the questions. He was tired of not knowing. He just wanted to be with his granddaughter. And you cannot read this letter and not see that this man was in pain. You can even see the effects of the drugs and alcohol as his handwriting deteriorates through this letter. This is not some self-serving, deliberately created manifesto of innocence. This is the cry of a man who just doesn't understand the world anymore. He doesn't understand what happened to his granddaughter. He doesn't understand why his daughter won't tell him. He just doesn't understand, and he's just tired. Caylee Marie, I miss her. I miss her. I want my family back. I sit here falling apart because I should have done more. She was so close to home. Why was she there? Who placed her there? Why is she gone? Why? For months, you and I, especially you, always questioned why. I want this to go away for Casey. What happened? Why could she not come to us, especially you? Why not Lee? Who is involved with this stuff for Caylee? Before that, he says, I blame myself for her being gone. You know, for months, as a matter of fact, for a year or so, I brought up stuff only to be told not to be negative. To denigrate that pain by suggesting that that is an insincere, selfish, self-serving statement, I believe, belies the facts. I'm going to sit down now, and Ms. Drain-Burdick will address some other areas in the case. I just want to end by thanking you for all of your sacrifices and all of your time, and to wish you well in the decision that you're about to make. Thank you.
Okay, ladies and gentlemen of the jury, we'll take a one a 15-minute, one a special one. Okay, we'll take a 20-minute special recess to the hour of 10 o'clock. You may be seated. Let the record reflect that the defendant is present along with counsel for the defendant, Assistant State Attorney. Both sides ready to proceed. Mr. Baez?
Yes, sir. I just have a brief issue that that I need to get on the record.
Yes, sir.
It relates to the issue dealing with the computer searches. You may recall that there was an issue as to the number of times that the chloroform website was visited, the SciSpot/chemistry/chloroform. Mr. Bradley testified based on a report introduced by the state of Florida that was actually compiled by Sergeant Stenger. This was the second report that was compiled a year later using a new software program in which they were having problems with, and the net analysis that was conducted on August of 2008 showed the identical website visited only once, and that 2 columns below was 84 times for MySpace, which did not show up on the cashback report. It is our understanding that the cashback report contains false information, and we have placed the state on notice that the testimony that was elicited was false. And we would ask at this time that the state of Florida, during the rebuttal argument, clarify that false testimony and advise the jury of its falsehood.
Response from the state?
Mr. Baez has already made his closing argument to the jury, Your Honor.
Folks, I don't know what you're saying is whether it's true or whether it's false. The only thing I can say is if there's evidence of false testimony, then you need to file an appropriate motion at the appropriate time, and I will take a look at it and see whether or not it is proven to be false. But at this stage, I can't chase after arguments. So file appropriate motions and we'll cross that bridge when we get to it. Anything else?
No, sir.
Okay, let's return to jury. Okay, the state recognized presence of jury. Defense?
Yes, sir, we do.
Rebuttal?
Good morning, ladies and gentlemen. When Judge Perry took that break for 15 or 20 minutes, I kind of felt like that guy that gets called out onto the field to kick a last-minute field goal once his teammate has taken the ball down to the 1-yard line. And of course, I'm ready to go, and the other team calls a timeout. So there are some advantages and disadvantages, I suppose, to being the last person to have a say on this subject. The advantage, of course, is the obvious one, that nobody gets to say anything after I sit down except for the judge on the law. The disadvantage, of course, is that you've been sitting here listening to attorneys tell you what they think the evidence shows for 5, 6, maybe even 7 hours to this point. And I recognize that you all are ready to begin the job that you have been here doing for almost 2 months. On May 9th, we packed our bags and spent 2 weeks in Clearwater, you have made a greater sacrifice in packing your bags and spending weeks here. And as everyone else before me has indicated, I thank you as well. But I ask that you do indulge me for a few moments to get our final thoughts on the issues that have been presented in this case. I promise that I won't be dragging out evidence or posters or pyrotechnics. If anything, that's not my style. When I came up here in May and stood in front of you for probably a little over 2 hours and told you what the evidence in this case would show, I meant what I said. I didn't make promises to you that the state didn't keep. I meant what I said. And through the testimony of dozens of witnesses, hundreds of exhibits, the state of Florida in this case has proven every element of every charge in this indictment against Caylee Marie Anthony. Mr. Baez, defense counsel, started his closing argument explaining what his biggest fear was in this case, and that it was that you would be making decisions based on emotion. I would never ask you to do that. Co-counsel has not asked you to do that. The judge will instruct you that you cannot do that. And although this case is certainly emotionally charged, we won't ask you to make decisions about the facts of this case based on anything but the testimony that you have heard from the witnesses and all of the exhibits that you will be able to consider once you begin the job of deliberating this case. Want to know what my biggest fear is? My biggest fear, and I do not, under any circumstances, mean this as an insult. My biggest fear is that common sense will be lost in all of the rhetoric of the case. That you won't step back and take a look at the evidence as a whole. You got to look at the big picture here. Co-counsel, in his opening argument to you yesterday, talked about rabbit holes. And after he sat down,
Sustain.
my fear is that you won't look at the big picture. We spent 2 weeks in Clearwater questioning all of you, looking for people who would still be able to see the forest for the trees.
Overruled at this point.
In his closing remarks, Mr. Baez used words like liar, perjurer, fraudulent. A trial in a criminal case is supposed to be a search for the truth. The truth is what is the cornerstone of the criminal justice process, both for those who are accused and those who are the victims of crime. It is lying that perverts that process. So during an argument where the most well-documented liar ever seen in a courtroom accuses everybody of perjury, of fraud, of lying, the irony is rich indeed.
Your Honor, a violation of paragraph number 5 of this court's order, and move to strike.
Rebuttal to the defendant's
Overruled.
argument. As we have come to find out, accusing others of lying is classic Caylee Anthony. When Caylee Anthony wants to divert attention away from herself, she accuses others.
Overruled at this point.
As we have heard from the evidence, Ms. Anthony has spent years lying, has spent 31 days. Mr. Baez, in his argument to you, suggested those 31 days mean nothing. A lie told convincingly is still a lie. The defendant, through counsel, has accused Yuri Melich,
Overruled at this point.
Jason Forgy, Gerardo Bloise, Dr. Voss, many of the witnesses that have come forward in this case of being liars. In his statement, he indicated that the Orange County Sheriff's Office is desperate, or was desperate in this case. And if there was anything that the individuals working for the Orange County Sheriff were, it was desperate to find a little girl. In July of 2008, whether or not she was alive or dead, the men and women of the Orange County Sheriff's Office labored for hours in an effort to find her. They were joined by the FBI, for law enforcement agencies all over the country, the Florida Department of Law Enforcement, Texas EquiSearch, citizens, people who had no other motive than to find Caylee Marie Anthony. But it was a lie. It was all in vain. Even the defendant's parents and her brother were searching in vain. You know, false allegations of child abduction are nothing new. And invariably, as in this case, it turns out that the perpetrator is a family member. The allegation of a false abduction diverts resources away from the perpetrator, diverts attention away from the perpetrator.
Your Honor, improper argument.
Overruled.
Buys the perpetrator more time. And you will remember, one of the things that Caylee Anthony said to her mother when she picked her up from her boyfriend Tony's apartment was that she just wanted another day. She wanted more time. She was trying to buy time. When she told her brother about the kidnapping, she was trying to buy time. Time to concoct another lie, another story, and to divert attention away from herself. In his argument, counsel put up pictures of all of the law enforcement officers who were at the Anthony home that night, suggesting there was no smell in the car because they took no action. That first night, July 15th of 2008, the police did not think Caylee Anthony was dead. At that point, they had no reason to believe Caylee Anthony was dead. There was no reason to connect any smell in the car to Caylee Anthony being dead. The defendant was telling them she was alive, that she was somewhere else. She was asking for their help in finding her. So much so that this episode that Mr. Mason talked about of Ms. Anthony being handcuffed was ended like that. Because the members of the Orange County Sheriff's Office were there to help. They weren't there threatening her to give a statement. They were there to help. The next day at Universal Studios, there were 3 long-term detectives who were there to help. If you listen to Ms. Anthony's statement again, they say to her, "You have 3 detectives here who want to help you, who will expend the resources to find your daughter. Why are you lying to us?" These aren't involuntary statements, as would be suggested, that you should just throw out. These are statements suggestive of a consciousness of guilt on Ms. Anthony's part. She was buying time, like she had done with her parents, her brother, her friends. The 31 days are really meaningless. Did I hear that? Did I hear a version of that? Counsel suggested that the detailing of what Ms. Anthony was doing during these 31 days had more to do with the state trying to prove that she was a slut. Did I hear that? Nothing could be further from the truth. Initially, the Orange County Sheriff's Office, in an effort to help her, was trying to backtrack and find out where she was and what she had been doing because she told them she was conducting her own investigation. Really? They were using her cell phone records to try to track down this Zenaida, to find Caylee Marie Anthony, to help the defendant. But as they backtracked, as you found out, it had become and did become more and more apparent that the defendant was lying about everything. If you go back and look at her 4-page written statement, the only true statement on there is that Caylee Marie Anthony was born on August 9th, 2005. That's it. every other statement on that form is a lie. You've heard during this trial, and it's been suggested to you in closing argument by the defense, that everybody grieves differently. Well, that may certainly be true. Everybody grieves differently. Responses to grief are as varied as the day is long, but responses to guilt are oh so predictable. What do guilty people do? They lie. They avoid. They run. They mislead. Not just their family, but the police. They divert attention away from themselves, and they act like nothing is wrong. That's why you heard about what happened those 31 days. Not to try to convince you to hate Caylee Anthony, but to show you that what she was doing during those 31 days was in no way indicative of grief, was in no way the response to someone whose child has died by accident. Counsel said, well, she could have hopped on a plane and left the jurisdiction. The classic signs of running away. Ms. Anthony did not have options. In those jail videotapes, you did hear, and if you listen to them again, will hear her say this was a time of desperation for her. And her father was like, what? Oh, desperation? What are you talking about, desperation? She had no option to go anywhere except away from her family. That's who she ran from, because those are the people who would be asking her all the questions. The friends are easy to placate. They're not really paying attention to her life. If she's telling them, my mom's crazy, or my parents are getting a divorce, or my dad had a heart attack.
Objection, Judge. Non-rebuttal.
Sustained.
31 days. She was running from her family during those days. The people who would want to know, more than just as a passing reference, where's Caylee?
Objection. The court sustained my objection, and counsel's continuing on that argument.
Argument is changed. Continue.
The defendant's actions and responses during those 31 days answer for you the only real question left at this stage of the proceedings. And that is, who killed Caylee Anthony? The question is no longer, where is Caylee? You will remember in my opening statement, I asked over and over again, where is Caylee Marie Anthony? We know where Caylee Marie Anthony is.
Objection, Judge. Non-rebuttal.
Overruled.
The question is no longer what happened to Caylee Marie Anthony. We know what happened to Caylee. The question is, who killed Caylee? For the longest time, Caylee was alive. Nobody killed Caylee. Caylee is alive. Until her remains are found. As I told you, as I warned you about in opening statement, as the facts and circumstances changed over the course of time, the defendant's lies changed. They got bigger. They got better. They involved more people. Mr. Baez, in his closing statement, would have you believe that there must be something wrong with Caylee Anthony because she has, quote unquote, imaginary friends. Those weren't imaginary friends. Those were lies. Every one of them was a lie. Ask yourselves, a lie designed to do what? A lie designed for a specific purpose. To get Caylee out of a jam. So for the longest time, Caylee is alive. Until her remains are found. And then, of course, the lie can't be Caylee is with the nanny. She's alive. She's been kidnapped. I had nothing to do with it.
May we approach?
No.
The lie must change. I told you in opening statement that it would. So now the theory is that there was some sort of accident. Well, you know from the evidence in this case that Caylee Anthony's death was no accident. First off, the Orange County Sheriff's Office proposed to Caylee Anthony on July 16th of 2008, maybe your baby died by accident. Can we hear that segment, please?
I had to sit down with mothers who rolled over in their babies accidentally. I've had to sit down with mothers whose kids have drowned in swimming pools. I've had to sit down with mothers who had boyfriends who beat their kids to death, who felt horrible about what happened, and I've had to go to them and help them try to explain to their families, okay? And then I've also had to deal with people who have done horrible, unspeakable things to children, and then lied about it, and lied about it, and lied about it, okay? And I'll bet you somewhere in there I've probably dealt with somebody who maybe made a mistake, but continued to lie about it, that maybe they weren't such a bad person, but maybe the whole world didn't see it that way. Maybe their family didn't see it that way because they kept lying about it. And then when it finally came, and months down the road, or days down the road, when they finally decided to come forward, okay, people were past it. You told me that you lied to me for the last time. I don't listen to what you have to say. Don't talk to me anymore, okay?
In his closing statement to you, counsel suggested that the Orange County Sheriff's Office had murder on their minds, that they didn't want to consider that this was an accident. You heard right there. Was this an accident, basically? I've dealt with tons and tons and tons and tons of people. I've seen it all. Was this an accident? No, Caylee is alive. The defendant's mother suggested the whole accident scenario involving the pool specifically. on August 16th of 2008. And can we hear that, please?
Well, someone just said that Caylee was dead this morning, that she drowned in the pool. That's the newest story out there. Surprise, surprise.
Surprise, surprise. So when Caylee Anthony is found dead on December 11th of 2008, surprise, surprise, it's an accident. No person would ever make the accidental death of a child look like murder. The defendant's actions during those 31 days and her response to this are completely inconsistent with what people do 100% of the time. You heard Dr. Garavaglia say 100% of the time when a child is involved in an accident, somebody tries to save them. They want them to live. They call 911. They anguish over the death of a child, especially if you want to accept this testimony that Miss Anthony was an amazing mother. Who did you hear that from? How was that defined? Her friends? People who don't have kids, that have other lives, that have seen 2 seconds of interaction? The questions in support of, what did you think about Caylee Anthony's relationship with her child, were things like, did Caylee run to her mother? Of course she did. Every baby loves their mother. They have every reason to. Their love is unconditional. Of course she's going to run to her mother, just like she ran to her grandparents. Well, Casey provided food and shelter and clothes for Caylee. That makes her a great mother. No, that makes her a mother. Maybe an adequate mother. But in reality, the food, the clothes, the shelter were provided by her grandparents. That's why Caylee was healthy and happy and well-fed and well taken care of and nicely dressed. Look at her room. Look at their backyard. What amazing parent acts with complete indifference to the accidental death of their child? You heard from the defense own expert an example of an amazing parent, a woman whose child died, and she wanted to go to the child's gravesite because that child had never been in a storm in the dark alone. That's an amazing mother. A mother who tried to protect her child, even in death. If this truly was an accident in the pool, Caylee Anthony would have been found floating in the pool, not floating in a swamp down the street. if this was an accident that George Anthony knew about. He told you, we wouldn't be here today. I wouldn't be here. They wouldn't be here. She wouldn't be here. You wouldn't be here.
Overruled.
If he was home, as they suggested, when there was an accident in the pool, he would have called 911. He would have tried CPR. He would never have scooped up his granddaughter and put her in a bag and threw her in the woods. Never. No paternal instinct. Did we watch the same jail videos? Mr. Ashton has covered this, but did we watch the same videos? Mr. Anthony said he would trade places with his daughter in a second.
This has been argued by Mr. Ashton.
Sustained.
This argument cannot be followed to any logical conclusion. The way these remains were disposed of shows complete indifference to the child. It speaks volumes about how the person who disposed of her really felt about her. Can we look at the picture of the playhouse, please? This is how George and Cindy Anthony felt about their granddaughter. They built her a playhouse in the backyard. George Anthony landscaped it for her, put a little mailbox out there for her with her name on it. Put a stone base.
Overruled.
Put a stone base under that playhouse so that Caylee wouldn't have to sit on the ground in case it was wet. So that Caylee wouldn't have to sit on the ground where an insect could crawl on her. On those jail videos, you heard Mr. Anthony over and over again trying to get Casey to talk to law enforcement, to the sheriff's office, to the Federal Bureau of Investigation. If he was so diabolical that he was trying to cover up something, why would he want his co-conspirator to talk to the cops? That makes no sense. I'm trying to engage in a cover-up, but I want you to talk to the cops. Not only does the disposal of those remains speak volumes about how Casey Anthony felt about Caylee, the phone call that she made to her parents the night that she was arrested, July 16th of 2008.
Non-rebuttal. It's the second closing argument.
Talking.
Overruled.
Hello?
Hello, this is a free call from Casey.
An inmate from the Orange County Correctional Center. For a rate quote, press 7. To accept this free call, press 0. To obtain a customer this call is subject to monitoring and recording. Thank you for using Global Tel-Link.
Casey? Mom.
Hey, sweetie.
Well, I just saw your nice little cameo on TV.
Which one?
What do you mean, which one?
Which one? I did 4 different ones, and I don't know. I haven't seen them all. I've only seen 1 or 2 so far.
You don't know what my involvement is and stuff?
Casey.
Mom.
What?
No.
I don't know what your involvement is, sweetheart. You're not telling me where she's at.
Because I don't fucking know where she's at. Are you kidding me?
Casey, don't waste your call to scream and holler at me.
Waste my call sitting in, the jail?
Whose fault is
bunks are?
Whose fault is you're sitting in the jail? You're blaming me that you're sitting in the jail?
Not
Blame
my
yourself
fault.
for telling lies. You mean it's not your fault? What do you mean it's not your fault, sweetheart? If you'd have told them the truth and not lied about everything, they wouldn't.
Do me a favor, just tell me what Tony's number is. I don't want to talk to you right now. Forget it.
I don't have his number.
We'll get it from Lee because I know Lee's at the house. I saw Mallory's car was out front. It was just on the news. They were just live outside the house.
I know they were.
Well, can you get Tony's number for me so I can call him?
Hey.
Hey, can you give me Tony's number?
I can do that. I don't know what real good it's going to do you at this point.
Well, I'd like to talk to him anyway.
Okay.
Because I called to talk to my mother, and it's a fucking waste. Oh, by the way, I don't want any of you coming up here when I have my first hearing for bond and everything else. Like, don't even fucking waste your time coming up here.
You know, you're making it real tough for anybody to want to try to even assist you with giving you somebody's phone number. You're not even letting me finish.
Well, Let's go ahead.
You're asking me for Tony's phone number so you can call him, and then you immediately want to start pressing towards me and saying, don't even worry about coming up here for all this stuff and trying to cut us out.
I'm not trying to cut anybody out.
I'm not going around and around with you. You know, that's pretty pointless. I'm not going to put everybody else through the same stuff that you've been putting the police and everybody else through for the last 24 hours and the stuff you've been putting Mom through for the last 4 or 5 weeks. I'm done with that. So you can tell me what's going on. Christina would love to talk to you because she thinks that you will tell her what's going on. Frankly, we're going to find out. Whatever's going on, it's going to be found out. So why not do it now? Save
There's
yourself
nothing to find out. There's absolutely nothing to find out, and that's even what I told the detective.
Well, you know, everything
I
that
have
you're
no
telling them
clue where
is a
Caylee
lie.
is. If I knew where Caylee was, do you think any of this would be happening? No.
Anyway, you only got a couple minutes for this, so I'm not going to let you completely waste it. Here's Christina. She thinks she can get through.
No, I want Tony's number. I'm not talking to anybody else.
Hello?
Hi, I'm glad everybody's at my house. I'll have to call you later. I'll have to call somebody to get your number. Do me a favor, get my brother back because I need Tony's number.
Okay, is there anything I can do for you?
I'm sitting in jail. There's nothing anybody can do right now.
Well, I'm just trying to be...
Oh, I know you are, honey. I absolutely know that you are, and I appreciate everything that you're trying to do, but I'd like to call Tony. He's not at my house, is he?
No,
Okay.
no, it's just me and your parents and Lee.
Okay. Well, can you do me a favor and get my brother back or get the number from him, please?
Does Tony have anything to do with Caylee?
No. Nothing.
Okay, so why do you want to talk to Tony? You probably don't want to tell me, do you?
Huh?
You probably don't want to tell me, do you?
I didn't hear what you said.
I said, does Tony have anything to do with Caylee?
No, Tony had nothing to do with Caylee.
Oh, so why do you want to talk to him? You probably don't want to tell me.
He's my boyfriend, and I want to actually try to sit and talk to him because I didn't get a chance to talk to him earlier because I got arrested on a fucking whim today because they're blaming me for stuff that I never would do, that I didn't do.
Okay. Well, I'm on your side. You know that, right?
Honey, I know that. I just want to talk to Tony and get a little bit of...
Casey, you have to tell me if you know anything about Caylee.
Sweetheart,
if anything happens to Caylee, Casey, I'll die. You understand? I'll die. If anything happens to that baby.
Oh, my God. Calling you guys? A waste. Huge waste. Honey, I love you. You know I would not let anything happen to my daughter. If I knew where she was, this wouldn't be going on.
So how come everybody's saying you're lying?
Because nobody's fucking listening to anything that I'm saying. The media completely misconstrued everything that I said. The fucking detectives told them fucking bullshit. They got all of their information from me, yet at the same time, they're twisting stuff. They've already said they're going to pin this on me if they don't find Caylee. They've already said that.
Well,
they arrested me because they said that...
Yeah, because they said that the person that you dropped Caylee with doesn't even exist.
Because, oh, look, they can't find her in the Florida database. She's not just from Florida. If they would actually listen to anything that I would have said to them, they would have had their lead. They maybe could have tracked her down. They haven't listened to a fucking thing that I've said.
Do you know that whoever has Caylee, nobody's going to get away with this? Nobody.
I know nobody's going to get away with it, but at the same time, the only way they're going to find Caylee is if they actually listen to what I'm saying, and I'm trying to help them, and they're not letting me help them.
So how can I help them find her? The best thing you can do, baby, is listen to me.
They need to look up her information in a New York database, in a North Carolina database, other places that she's lived outside of Florida. That's what I told them even again today. I told them that 4 times today. I sat up at the police station, up at the county police station for
But she's the one who has Caylee, or she transferred Caylee to somebody else? Because
honey, I haven't talked to her. I don't know. I haven't talked to her.
How come everybody's saying that you're not upset, that you're not crying, that you show no caring of where Caylee is at all?
Because I'm not sitting here fucking crying every 2 seconds because I have to stay composed to talk to detectives, to make other phone calls, to do other things. I can't sit here and be crying every 2 seconds like I want to. I can't.
Okay, Casey, don't yell at me. I'm on your side. I'm on your side.
I know you're not.
Trust me.
I know you're on my side. I'm not trying
Nobody
to yell at you.
is saying anything bad about you. Your family is with you 100%.
No, they're not. That's bullshit because I just watched the fucking news and heard everything that my mom said. Nobody in my own family is on my side.
Yes, they are. Nobody has said...
They just want Caylee back. That's all they're worried about right now, is getting Caylee back. And you know what? That's all I care about right now.
Casey, your daughter, your flesh and blood, your baby girl.
Christina, please, put my brother back on the phone. I don't want to get into this with you right now. I love you, honey, and I'm glad that you're there. Thank you for your help. I will let you know if there's anything that you can do.
You can't tell me anybody that can find Caylee. Nobody.
No, because every number that I've tried, every number that I've called is disconnected. Nothing. I can't get a hold of anybody.
But that girl was the last person to have her?
She was the last person to have her. That was the last time I saw Caylee.
Okay. He doesn't... Lee said he doesn't have Tony's phone number.
Yes, he does. He has Tony's phone number in his phone. He needs to stop fucking lying. He just told me a second ago that he'd give me the number.
So if I go and I get you Tony's number, are you going to finish talking to me?
I will call you tomorrow. I want to talk to him really quick now. I don't want to actually try to close my eyes. I haven't slept in 4 days. I have not slept in 4 days.
Listen, if you're going to talk to anybody, you can talk to me, and you know that.
I can talk to you, but at the same time, I know I can talk to Tony, and that's who I want to talk to right now. I haven't gotten a chance to talk to him since this morning.
When you use your common sense, you can listen and hear that there's nothing that's wrong with Caylee Anthony that can't be explained using 2 words: pathological liar. She's not grieving the accidental death of her daughter. Her focus in that call was where it had been for that day and the 31 days preceding it, and that is with Tony Lazzaro. That's all she wanted to do when she called her parents, aside from cuss them out. I want Tony's number. You have learned during the course of this trial that Caylee Anthony is the only person who had access to every single piece of evidence discussed by Mr. Ashton today and yesterday. The duct tape, the laundry bag, the blanket, the shorts, the car. There's no evidence that anyone other than Caylee Anthony was driving around in that car that began to smell to the point where she is texting her friend, Amy Huizenga, "I think my dad has run over a dead animal." She texted that to Amy Huizenga about 15 minutes before her boyfriend, Tony, picked her up at the Amscot. So you would think if your car smells like there's a dead animal plastered to the frame of it, maybe you check the trunk. Maybe you see if there's a garbage bag or a trash bag in the trunk. That trash bag was placed there as a decoy. You heard testimony from Catherine Sanchez that car was backed into that spot by the dumpster. Why the dumpster? Guess why the dumpster? Because in addition to the bag of trash, the dumpster was a decoy to keep people either away from the car or thinking that was the source of the odor. The Anthonys didn't have access to that car. George Anthony didn't know where that car was. Miss Anthony was on the way to the boyfriend that her parents didn't even know existed. How would they know where to find her car? She told her mother she was in Tampa or Jacksonville or somewhere. They didn't know where she was or where the car was. And finally, the shirt. Big trouble comes in small packages. Indeed. Cindy Anthony told you that shirt was not one that she was familiar with. She did the laundry. That shirt was not kept at the Anthony house on Hope Spring Drive. That shirt was kept in the car, in the diaper bag or a backpack, because we saw it on 2 different occasions at Ricardo Morales' apartment in January of 2008, and then again in March. Someone in that house killed Caylee Anthony. They want you to believe it was George who was involved in a cover-up of an accident that did not happen. Even George Anthony didn't have access to all of these things. Only Caylee Anthony did. No one else tried to cover up and lie and lie and lie and lie, and I can go on a dozen or more times. Where were George and Cindy? Let's throw Cindy into the mix too as a possible perpetrator, because Caylee Anthony would have you believe that this is all her mother's fault anyway for leaving the ladder down. Let's twist the knife in my mom a little more. The cover-up is her dad's fault. Let's twist the knife in him too. What were George and Cindy Anthony doing in June and July of 2008? They're living at home. They're going to work. And they're missing their granddaughter. What's Casey Anthony doing? Where is Casey Anthony? Well, she's not where she normally is, at home. She's at Tony's, because that's who saw her. She tells her mom she's in Tampa or Jacksonville or wherever. She's not where she's supposed to be. And where's Caylee? Caylee's dead in the woods. At the end of this case, all you really have to do is ask yourself a simple question. Whose life was better without Caylee? Was Cindy Anthony's life better?
I called a little bit ago, the deputy sheriff saying I found out my granddaughter has been taken. She has been missing for a month. Her mother finally admitted that she's been missing. Okay, what is here now? Okay, what is the address that you're calling from? 4937 Hope Spring Drive. We're talking about a 3-year-old little girl. 4937 what? Hope Spring, HOPESPRING Drive, Orlando. My daughter finally admitted that the baby's in the store. I need to find her. Your daughter admitted that the baby is where? But the babysitter took her a month ago that my daughter's been looking for. I told you my daughter was missing for a month. I just found her today, but I can't find my granddaughter. And she just admitted to me that she's been trying to find her herself. There's something wrong. I found my daughter's car today, and it smells like there's been a dead body in the damn car. Okay, what is the 3-year-old's name?
Was George Anthony's life better? Mr. Ashton went over what George Anthony's life was like as a result of losing his beloved granddaughter. Whose life was better? That's the only question you need to answer in considering why Caylee Marie Anthony was left on the side of the road dead. There's your answer. Thank you, Your Honor.
Okay, ladies and gentlemen of the jury, we're going to take a brief recess. When you return, you will hear the final instructions on the law from the court. We'll be in recess. Okay, has both sides had an opportunity to look at and review the final instructions?
Yes, sir.
Defense?
Yes, sir.
Okay.
Your Honor, I have a motion at this time.
Yes, sir.
Yes, the defense would make a motion for a mistrial based on 2 improper comments by both counsels during their second and third closing arguments. One would be the comments by Mr. Ashton, where he stated that there was no evidence, no evidence or explanation of where it came from, creating a burden on the defense to give an explanation of where the chloroform came from. The second comment would be on Ms. Drain Burdick's statement, where she had stated that the defendant had changed her story once the remains were found. This is an improper comment, improper argument based on statements that were never made by Ms. Anthony. Ms. Anthony did not testify, and to make false statements as such would be improper argument. And for those reasons, we would move for a mistrial.
Motion for mistrial will be denied.
Last packet of verdict forms. This one does not have 2 special finding forms.
Mr. Mason, turn the speaker on. Please, sir.
Verdict form, complete package, missing the 2 special finding ones. You have the last one, Frank.
Mr. Mason, you may also want to inspect the verdict forms that I will be reading to the jury. Make sure those are the same ones that we discussed yesterday. I would need them back, but please inspect them. While you're reviewing those, the rules of criminal procedure provides that there are certain instructions I need to give the alternate jurors because of the nature of this particular case. The instructions specifically provide that they are to remain in the courtroom and that I am to give them the instructions. Generally, that's what I generally do. This case is somewhat unusual in the sense of media and public interest. What I've done in the past is I will do that. They will go out of that front door and then they'll go about their business. This particular case, they cannot do this. This is what I propose to do. I have made arrangements with the court deputies that I will excuse those individuals, but they will go through the same door with the rest of the jurors, but they will be promptly taken down to a location in this building. They will be held there, and I will go with the court reporter. If you or the state want one representative present, you can, and then I will instruct them, but they will still be sequestered until there will be a verdict in this particular case. But there are some special instructions that I'm going to need to give them, particularly in light of the fact of bookers who have arrived in town trying to book jurors for shows. Any objections from the state of Florida?
No, Your Honor, that sounds.
Any objections from the defense?
Not from the defense.
Okay. Okay, to the audience. When I return back in the next 10 minutes, I will give the jury their final instructions. No one will be permitted to leave. So if you want to leave, my suggestion is you leave now, because you will not be permitted to leave, get up, walk around, do anything. Court deputies have been instructed if someone does that, they will deal with you accordingly. So if you want to leave, now is the time to leave and not return. Okay, we'll be in recess for 10 minutes.